Now the next provision we have to take up under quasi contracts is section 70 of the Indian Contract Act, which deals with obligation of person enjoying benefit of a non-gratuitous act. What do we mean by a non-gratuitous act, or for that matter gratuitous act? When we say gratuitous act, we mean that, say for example, I am just trying to help another person without expecting anything in return. So acting in a gratuitous manner means you do something for someone without expecting anything in return. But here, in contrast to a gratuitous act, we are referring to a non-gratuitous act. So obligation of a person who is enjoying benefit of non-gratuitous act. So it says, where a person lawfully does anything for another person or delivers anything to him. So does anything for another person or is delivering anything to him, not intending to do so gratuitously. So if I have done a lawful act, lawfully if I have done something for another person or I have delivered something to that person, right, and my intention is not at all to act in a gratuitous manner or to do something for that person or deliver something to that person and just forget about it. That is not my intention. And such other person for whom that act was done, whose the act's benefit with the person is availing, or the person to whom certain goods were delivered and that person has taken benefit of those goods, then in that case such person who is enjoying the benefit thereof is bound to make compensation. Now in section 60 the terminology used was reimbursement, right, because you are returning what you have got, you are returning it, that is why reimbursement. Here we are talking about compensation, right, because it says you have enjoyed the benefit of that property. It is not that you had taken care of it and now you are returning it back. You have benefited out of that property, so that is why now you will have to compensate the other person. To make compensation to the former, that is who delivered the goods or who did something for you, in respect of or to restore the thing so done or delivered. So it is talking about two things: compensation. Say compensation if you have used that thing, if you have consumed it, or if you have already availed benefit of it, right, then you have to compensate the other person who had unintentionally done that act for you, unintentionally committed that act for you. Next is talking about restoration. So section 70 is using two terms, compensate or restore. So if you have a thing, if you have those those goods available in your possession, something which was delivered to you, if it is still available with you, you can restore it back to the person to whom that thing belongs, right, because if you have it in your possession and you have not done anything as such with it, or even if you have used it, it is still in a position that it can be returned back. So please, you are supposed to, under section 70, restore that thing back to that person, or if you have consumed it, finished it, it cannot be returned or it is not traceable in your possession anymore, you have already benefited out of it, then in that situation you will have to suitably compensate the other party. Now there is this judgment of State of West Bengal versus B.K. Mondal and Sons. It is a 1962 Supreme Court judgment where the Supreme Court has identified certain essentials of section 70. First is, person should lawfully do something for another person. See, again and again the emphasis is you should have done something lawfully, some lawful act for another person. Should lawfully do something for another person or deliver something to him. In doing the said thing or delivering the said thing, he must not intend to act gratuitously, and the other person for whom something is done or to whom something is delivered must have enjoyed the benefit thereof. So first essential is that something has been done or something has been delivered. Second thing is that such act of doing something or delivering something is a non-gratuitous act. The third requirement is that the result of that non-gratuitous act or the result of doing something for someone or delivering something to someone is that the other person for whom that act was done or to whom the things were delivered has benefited out of the non-gratuitous act. So, that is required. Now, in B.K. Mondal and Sons case, this thing had happened because B.K. Mondal and Sons, this company, they had made an offer to the government and that offer had been accepted, and they had built certain temporary godowns in the Hooghly district in Calcutta. They in West Bengal, they had made this temporary godowns, right, this company. So, once that was made, he prepared a bill and he submitted the bill, the payment was made to him, and but according to him, further what happened because of which he had to come to the court was that he says he was asked by one of the officers of the civil supplies department for whom he had created those temporary godowns and other things, other structures. So, he says that after this further twice, one of the officers of that department asked me to do certain other works for the department, and he did those works, but when he has presented the bills, the two bills were unpaid, and that is the reason he had to approach the court, because the government was of the view that there was no valid contract which had been entered into for the latter two constructions. There was no contract which had been entered into between B.K. Mondal and Sons and the government, the civil supplies department, basically the government, state of West Bengal. Therefore, he cannot claim that recovery of that money, he cannot do that. Now then he took the help of section 70 of the Indian Contract Act, that B.K. Mondal and Sons, being a construction company, if is doing some kind of construction that is not intended to be a gratuitous act, if it has been done and he was clear in his mind, the person representing B.K. Mondal and Sons was very clear in the mind that the company was asked by this government officer to do these constructions, and if it has been done, and mind you, when these constructions were done, the latter two constructions have been done, they have been used, they have been benefited, they have been taken benefit of by the government. So, further, then the court held that you did not object to it. If you actually are saying that there was no valid contract and therefore you are not under any obligation to make payment for it, then at that time itself, when those structures were constructed, you should have asked the company to destroy those structures or to break those structures, because there was no contract and you did not want those structures. But here in the situation was that the structures were built and they were used, they were taken benefit of by the government. So, then the court said that fine, agreed, even if there was no valid contract, but section 70, which is a quasi contract, makes you it is putting you under an obligation. You can see the opening words of the section 70, obligation of person. So, it is putting you under an obligation. Why? Because all the three essentials are being met. Person should lawfully do something. Yes, it was a construction company who had lawfully constructed structure for the government. Then in doing the said thing, he must not intend to act gratuitously. There was no evidence in existence which could show that the company, by constructing those structures, was acting in a gratuitous manner, that is, not expecting anything in return. Thirdly, other person for whom something is done have enjoyed the benefit thereof. So, yes, in this case also the government did enjoy the benefit of the construction which was done. So, the court took a decision in favor of B.K. Mondal and Sons. Moving to the next provision, that is section 71 of the Indian Contract Act, which talks about responsibility of finder of goods. There is a very common saying in law, that is finder keeper. Finder keeper. That is, he who finds something which originally does not belong to him. So, if he has found something, he can keep that thing with him, right. So, if you have found some goods which do not belong to you, or and which you do not know to whom it belongs, finder can keep it, but there are certain prerequisites. What are those? Let us see. Responsibility of finder of goods. A person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as a bailee, right. That is, you can say, as a custodian. A thing does not belong to you, you have found it from somewhere, you have taken it in your custody. Now the law says, now you have a duty, and that duty is equivalent to that of a bailee, that is custodian of that property. Now what you have to do is, you have to make effort to find out the true owner of that property if it is possible. If you do not make any effort and consume that thing, you can be made liable by the court of the law, and you can be asked to compensate, right. But first thing you have to do is, you have to try and find out the true owner, because again in law it is said that possession is 9/10 of ownership. That is, owner has 10, if owner has 10 rights in relation to property, the person who actually is possessing that property but is not the true owner has 9 rights, that is 1 right less, right. So, finder may have I won't say best title, finder may have a better title on that property against anyone else, but except for the true owner of that property, right. So, when we say the same responsibility as a bailee, let us see what are the responsibilities of bailee. So, basically section 151 and 152 of the Indian Contract Act lay down, or basically state, if I may say, the responsibility of a bailee or the custodian of a property. In all cases of bailment, the bailee is bound to take as much care of the goods bailed to him as a man of ordinary prudence would, under similar circumstances, take of his own goods of the same bulk, that is same quantity, quality and value, right. So, if you have if something has been entrusted to you, something has been given to you, you have to take care, or something is in your custody, you have to take care of that property in a similar manner as if it was your own property, or if I may just rephrase it, if you have to take care of that property in the same manner as you would have taken care of your own property, not that this is your property, but you would have taken care of your own property of same quantity, same quality and same value, right. So, basically 151 is talking about reasonable care. 152 talks about the bailee, in the absence of any special contract, is not responsible for the loss, destruction or deterioration of the thing bailed. So, if you have found something, and say even if you are waiting for, you are trying to find out the true owner. So, if something happens to the goods which you have found, they get destroyed, perish away, or something happens to it, you cannot be held liable. You being the bailee, the custodian of that property, the finder of the property here, you cannot be held liable for any kind of loss or destruction which could have happened to that property, right. If provided you have taken equivalent care of that property as mentioned under section 151. Now, let us move on to the last provision under quasi contracts, that is section 72. Section 72 of the Indian Contract Act talks about liability of a person to whom money is paid or thing delivered by mistake or under coercion. The two things mentioned are mistake or coercion. So, if money has been paid to you or something has been delivered to you as a result of some mistake or coercion, then in that case you have a liability which you owe to that person. What is that liability? Let's see. A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. So, if money has been paid, it has to be repaid. If thing has been delivered, it has to be returned, right? So, many a times you will see that the language of the law is that you have to, the sentences are too long. So, you have to read it very carefully to be able to make some meaning out of it, right? So, money is to be paid. Money, the correct terminology to be used is in relation to money, repay, and in relation to something delivered, return, right? Because a thing which has been delivered, it cannot be repaid, it can only be delivered, returned. Now, one instance here, let us see, payment by mistake in section 72 refers to a payment which was not legally due, it was not legally due and which could not have been enforced, right. So, payment by mistake, if I have mistakenly given extra amount to a person whom I was supposed to give a particular amount of money, if under mistake I have given more money to that person. So, this point says here that it was not legally due, I was supposed to pay him a particular amount of money, but mistakenly I have given additional amount and which could not have been enforced. The mistake is in relation to thinking that the money paid was due when in fact it was not due. There is a slight difference now here. So, in order to understand this last point which has been written here, that is the mistake is in relation to thinking that the money paid was due when in fact it was not due. So, let us just slightly modify the example which I had given you, wherein I said that you were supposed to give a particular amount of money to a person, but instead you ended up giving additional amount to that person under mistake. Now, what do we mean by this thing here? That you are thinking that a particular amount of money is due on you which you have to pay that person. You think it is a particular amount of money, but and you give that money to that person under a mistaken impression, but in reality a lesser amount was due, right. So, he is supposed to, that person is under an obligation and is supposed to return that additional amount to you. You thought that you have given the right amount of payment, but it is not actually true and you were supposed to give a lesser amount. So, it is the duty on the part of that person to return that amount back to you. So, there is an illustration on your screens which has been taken from section 72. Let us see what it says. A and B jointly owe 100 rupees to C. A alone pays the amount to C. Now, A and B, they jointly owe 100 rupees to C. A alone, out of his own free will, he has paid that 100 rupees to C, and B is not aware of this, and B also, not knowing about the fact that A has already paid C, again pays 100 rupees to C. Now, B is not aware of that. So, it is the duty, the liability of that person to whom that money has gone twice to repay and return that amount of money back to B, who in ignorance of the fact that A has already paid, has again paid that amount. So, it is the liability on part of the C, because he is not entitled to that additional 100 rupees. So, he has to return that money back to B. One more illustration we can see under section 72, that is, a railway company refuses to deliver certain goods to the consignee except upon the payment of an illegal charge for carriage. So, section 72 is not restricted to mistake, it is also making a reference to coercion. So, the previous example illustration which we discussed was pertaining to mistake. This illustration here is pertaining to what we call as coercion. So, railway company is refusing to deliver goods to a consignee except upon the payment of an illegal charge of carriage. Consignee does not have an option at that time. Consignee pays the sum because his property has been unlawfully detained and he does not have any option but to pay that additional charge. So, the consignee pays the sum charged in order to obtain the goods. He is entitled to recover so much of the charge as was illegally excessive, right. So, these two illustrations were in relation to section 72. Let us move on towards the last two points which we have to discuss in